To begin and provide a frame of reference, there are state and federal laws that prohibit discrimination on the basis of race, sex, age, religion, national origin, disability, Vietnam era veteran status, other protected veteran status, things of this matter. You will not find a law that expressly prohibits sexual harassment. Rather, harassment is merely one type of discrimination that occurs. And again, we tend to use language very generically, so a lot of us feel like we're harassed on a daily basis. And it may be perfectly legal, and you may still indeed be harassed, but the basis of your harassment is not your race, sex, age, religion, national origin, etc. Today, I'm obviously going to focus on the issue of sexual harassment, although all types of harassment are equally a violation of state's federal law, and they're all equally bad. There's probably more case history. There are certainly more regulations from various federal agencies that deal with the issue of sexual harassment than with the other types of harassment, although they parallel each other in many ways in terms of how we define them. To start from the sort of basics, harassment first and foremost has to be unwelcome behavior. If you don't object to the language or the treatment that you're receiving, obviously this can't be a violation. And there are two basic types of sexual harassment. One is called quid pro quo, and it literally means a promise, this for that. So it's a promise of a benefit in exchange for sexual favors or tolerating behavior of a sexual nature, or it's a threat of a penalty if you don't go along with requests for sexual favors. It's also important to remember that when we talk about harassment, we're talking strictly about an employment environment or an educational environment. What you all do and how you interact with each other in a purely social circumstance, and if there is no other educational context or other employment context, you can do virtually whatever you want to, unless it violates some other law in terms of civil rights. But the issue of harassment is, again, limited to an employment or an educational context. So the quid pro quo, the example we use at the university in an employment context is that if your supervisor suggests to you that the place you need to go to have a performance evaluation is here at this hotel, there's no explicit suggestion that we're going to base your evaluation on your performance here in this hotel, but certainly there is an implied suggestion that you're being evaluated for behavior unrelated to your work. That would be an example of quid pro quo harassment. It can be either implied or it can be explicit kinds of requests. And again, in that kind of circumstance, the suggestion is if you don't go along with the request to do your performance evaluation in a hotel, then somehow there would be some sort of penalty associated with that. Most often, quid pro quo situations are related to somebody who's in a supervisory role over somebody who is being supervised. It's very difficult for two coworkers to engage in quid pro quo harassment towards each other. Federal regulations are such that for employers nowadays, if we know about or should have known about harassment, particularly by a supervisor, and fail to take immediate corrective action, then you are even more vulnerable if that employee decides to go to court or a federal agency such as the Equal Employment Opportunity Commission to try to get redress for the behavior. Now, there are some affirmative defenses that employers have, but by and large, somehow we're supposed to know what our people are doing, and particularly if they are in a supervisory role. So you can imagine for an entity like ASU, we're both an educational institution and an employer, so how our faculty treat our students, that's an issue that we have to address, as well as literal employment relationships between, for instance, I'm a director and I have 8 people that I supervise. So we've got those issues. Additionally, employers must keep its employees from being harassed by members of the public. Again, you could potentially have a quid pro quo situation from a member of the public. If you're in the business of somebody's trying to sell your company something or offer something and your company wants to negotiate that deal, clearly one of the anecdotes that gets told a lot by women in employment situations is that their company has expected them to engage in whatever behavior was necessary to make the sale or get the best price on a product or something like that. That would clearly be an example of quid pro quo harassment and would be inappropriate. Probably the more typical kind of harassment is what's called hostile environment harassment. Again, the behavior is unwelcome and it creates a hostile, intimidating, or offensive environment. Several years ago, there was a court case, Harris versus Forklift, and in that court case, among many principles that were established, the critical one in terms of defining hostile environment is that the behavior has to be pervasive enough and or severe enough to literally alter the environment as defined by a reasonable person. Reasonable person is a court standard used that's come into question as to whether or not a reasonable person really is the same as whoever the victim of harassment may be, because there's an overwhelming tendency for reasonable person standard to be viewed as a white male value rather than values of other cultural entities, and particularly for women. The court didn't accept that argument when people tried to make that. The Supreme Court, they left it at just a reasonable person. So again, in a hostile environment kind of situation, it can be the language that's being used, it can be pictures that are being shown, it can be things that are left around your work area. There have been a number of different court cases and examples where women have found Playboys or pictures like that, or feminine hygiene products or other kinds of things left as a way of trying to harass them. And again, if the behavior, that kind of activity is pervasive enough and or severe enough to alter the environment, then those are the circumstances where somebody would be found guilty of hostile environment harassment. Again, using the university as an example, the example I give to students particularly is that if this were a classroom and I walked in at the beginning of the class and I said, all right, I want all men to sit at the back of the room because I basically consider men stupid, any male thinks you're going to get fair and equitable treatment from me. Nobody wants to give me the benefit of the doubt on that one. That's an example where my one-time comment, although it's not sexual in nature, it's clearly directed based on gender, and at least under ASU policy and probably under state and federal law, I'm going to be found guilty of hostile environment harassment because I've altered your environment because you can't expect equity.
Does it have to be one time only, or does it have to be recurring?
Here's an example where a one-time only comment, I would still be guilty. If, on the other hand, for instance, I walked in a classroom situation and I told a joke where one gender was the object of the joke, it may be unprofessional, it may be stupid, it may be inappropriate behavior, but if that's the only thing I do all semester long, then I'm not going to be guilty of sexual harassment because it doesn't appreciably alter your environment. You don't have to fear coming into the class. Again, I apologize that so many of my examples are university, but that's the only world I know, really. But to try to give you, again, sort of a frame of reference. I had a faculty member who taught a huge class, it's one of these large lecture halls with 200 or 300 people. And as he would walk into the class, he would make a point of stopping to talk to, it was a young woman, hi, how are you doing? Gosh, she's had a new hairdo. Nothing that was particularly sexual, and by most people's values, the comments were actually positive. She came to the office to complain that she was being harassed because students around her started making jokes about the fact that, oh, why does this faculty member seem to be so friendly to you? It's not that he doesn't say hi to other students in the class, but seems to focus on her. In talking to the faculty member, his rationale was that this is a woman who came from a culture that he identified as, for females, stereotypically passive, that she was not doing well in the course. He had written notes on tests. Teaching assistants in the class had written notes encouraging her to come and get assistance so that she could pass the class. And so he was trying to let her know that he was friendly and approachable as his way of trying to encourage her to take advantage of some of those offers of assistance. And explain to him that, again, good intentions, but they're backfiring rather dramatically because the student feels like she's being singled out and now is an object of humor from her student colleagues, and he needed to accept the fact that she's an adult and she gets to make choices as to whether or not she will accept help, and his view of her as stereotypically passive may or may not be accurate. And so, again, he needed to stop doing that, which he was fully willing to do. You know, towards the end of the semester, talked to the student again, you know, how's everything? Did the faculty member stop? Yeah, he stopped. The student stopped making jokes. Did she pass the class? No, she did not. But again, that was her choice. And, you know, here's where the key issue to remember is that in a definition of hostile environment harassment, it is the impact of the behavior that defines it, not the intent. And so, again, back to the faculty situation, I come in and I tell jokes. I'm trying to lighten the environment, trying to help people realize that I'm friendly and approachable. Good intentions may backfire because the impact on people is that the jokes are inappropriate for the classroom environment, and because they use a particular social identity as the object of those jokes, then after a while it does become a hostile environment because you have to worry about who's going to get picked on next. I don't want to have to hear this at the beginning of every classroom kind of situation. Most employers deal with hostile environment harassment more often. And it's everything as simple as you and I know each other. We tell jokes where women may be the object, men may be the object, you know, call them dirty jokes if you want to. But that's perfectly fine at work. We know each other, we have permissions, we share a similar kind of sense of humor. But what we're not aware of is that when we're telling those jokes, every single time, you two hear us. We're not talking to you, we're not talking about you, but we're in a work environment where you don't have the flexibility of just getting up and leaving anytime you want to get away from a situation. And so consequently, what to us is, you know, friendly, joking behavior, to other people is now beginning to create a hostile environment because they can't get their work done because they're forced to, in terms of the physical space, listen to jokes that they find offensive. If they were to go and complain to the employer, we would potentially be guilty of sexual harassment under those circumstances because, again, if it goes on long enough, we are literally altering their environment because they can't get out of it and they're forced to endure these kinds of situations. Yeah?
Well, what about now with email and that? Is that
it's created a
regarding that
whole new world of harassment, unfortunately.
Because, like you cited, the other two people don't hear it at this point, but
again, oftentimes in an educational environment, we have computer labs for our students and employees to use. And we balance some very interesting rights. On the one hand, we're required, again, by law to protect everybody from being sexually harassed. We offer courses at the university in some very controversial subjects, in many cases by many people's values. And so we frequently have students in those open spaces looking at websites that some people would identify as extremely sexual, pornographic, you know, pick whatever term is meaningful to you. And so we routinely get comments and concerns about that person who's looking at, quote, the pornographic side shouldn't be allowed to do that because it's an open public setting. And then we have to go to great lengths to explain there's a concept called free speech. And we have every obligation to protect free speech to the same extent that we have to protect your right not to be sexually harassed by being exposed to this material in the environment over which we have control. That's a particularly difficult set of rights to balance, quite frankly. We don't force somebody to stop looking at something because they may legitimately be engaged in research for a class. So we try to offer alternative environments or have our computers set up so that it's less likely that you are automatically exposed to somebody else's computer screen. I mean, as the evolution of computers has occurred, we've gone from the minute you turn it on, you can change the wallpaper, you all know what wallpaper is, and things like that, so that now then on all of our public computer sites, nobody can touch the wallpaper. That is, you know, we've got at least so far, hack-proof. As soon as I say that, I'll get a story on Monday about somebody who's hacked in to do that. So that it's impossible for people to access and leave information on the screen so that as soon as you pull it up, you're exposed to that. We also have people who now, again, given computer technology, and I hope I'm not giving anybody ideas here, but try to route the email through somebody else's email address. We had a student several years ago who came in with a fairly graphic picture that was sent to her, as well as suggestions as to a behavior that she and happened to be an associate dean could engage in. So she responded back to him and said, "How dare you? Please don't ever send anything like this." And this associate dean's going, "Who are you? What are you talking about?" And we, because it occurred within the computer system at ASU, were able to track down who the individual was that sent the email. And it was a student who's no longer a student there. So you had multiple layers of violations. One, sending an email through somebody else's email address. Two, the harassing kinds of comments. So computers are wonderful, but they get used in ways that are not so ideal. Just to make, you had a question
yes,
first.
I have a concern. I'm a First Amendment lawyer in Los Angeles, and I've spent my entire life fighting the far right. But quite frankly, recently, I found what I call left-wing censorship, which kind of abuts this type of situation, and I can see it as stifling of the First Amendment as the right-wing religious craziness. I'll give you an example. Part of what I do in my law practice is represent women arrested for prostitution, and I am an activist in California to decriminalize prostitution. At a local university, I was invited by a woman professor to address her women's sexuality class on why prostitution should no longer be a crime. And I was defending prostitutes and prostitution. The previous week they had a contrary speaker. Well, an African-American student complained to the administration that the professor had subjected her to sexual harassment because she felt sexually harassed by my presentation. And the university was actually starting to proceed against the professor until I threatened them with a civil rights action.
Then that's people there who don't know what they're doing, if that's the case. You're right, we would never do that here.
Yeah, so I'm just saying that there's, when we talk about balancing, and the other, you see, the other concern I have, which maybe you can address, is the concept of allowing certain cultural backgrounds to vary the reasonable person standard. Because in First Amendment law, we have what we call the heckler's veto, where when you address something to a group of people, whatever is unique to a listener that takes offense should not be sufficient to overcome your First Amendment right to make the expression. So while I'm sympathetic to everything you're saying, as sort of a First Amendment universalist, and as someone who's fought what I call left-wing political correctness on college campuses, as well as the crazy religious right, I have concerns.
Again, I think that is difficult. What happened in the early 90s, we started getting district court cases that said when you evaluate whether or not there is a hostile environment for women, the values that ought to be used to evaluate that should be women's values, because in most cultures, males and females are socialized differently. And there are a lot of different stereotypes. And so could a male view really understand why women felt harassed? Again, back to the impact, the severity, and how pervasive the behavior is. So you actually had a couple of courts that were saying that the reasonable person ought to be, if a female is the victim in this situation, the reasonable person ought to be a reasonable woman's view. EEOC, the Equal Employment Opportunity Commission, even went so far as to come out with some guidelines saying that, again, when you are evaluating harassment cases, that the reasonable person ought to be individuals who are of similar culture, gender, because, again, of those cultural variations in terms of what's going to qualify. And that's what the Supreme Court said, no, we're not going to go that direction. It's going to be whatever that generic reasonable person standard is. And so EEOC had to rescind their regulations and things like that. I think, again, like anything else, the people who implement the laws or the policies for an employer, I mean, I've heard of some utterly ridiculous things in my view, things that fortunately ASU would not engage in. But I do think it does become difficult at times to know which is the greater right. I mean, we've had some very interesting discussions on the whole issue of, again, somebody's right to look at whatever they want to on a computer versus somebody's right not to have to be exposed to that in our educational environment, and then how do you fix that without violating somebody's rights? Because the minute you ask one or the other to move, you start to impinge on their rights to, utilize that space. And I don't have solid answers. I mean, we look at everything on a case-by-case basis to try to, resolve. I mean, the good news is I think that the vast majority of people are very reasonable. And if they know that whatever they're looking at is offensive to somebody else, they're willing to shift that computer 6 inches so that it's not readily viewable, or physically get up and move to another computer, or whoever's offended gets up and moves. I mean, to me there's some real common sense elements here, rather than standing on, but it's my right, and it's like, okay, but we've got multiple rights, how do we make sure everybody's rights get effectively addressed? And sometimes we do that. I mean, I still remember after a Seinfeld episode, and I didn't watch it, I wasn't a Seinfeld fan, but again, mispronounced a woman's name that had some sexual overtone. And somebody was allegedly talking about that at work, and the company fired him. I mean, that was the most absurd. Fortunately, he sued and won, because that would have been utterly ridiculous. I mean, no way would that have qualified, I think, in terms of pervasive or severe enough. And I think one of the dilemmas with any kind of issue, I know when I talked about harassment 20 years ago, used to get a standard response from a lot of folks of, well, you just can't talk to anybody, I can't be complimentary, you can't tell any kind of jokes, to which, depending on my audience, I would be blunt or not so blunt, saying, let's get real here. We're talking about concepts of professionalism and courtesy. And why would you want to use language or behavior that's going to be offensive to someone? I mean, if you want somebody doing that, yes, you can tell jokes. Just be aware of your surroundings in terms of who can overhear. Be a little bit more thoughtful about the language that you use. We don't all want to be referred to by some term. Ask questions. These are new communication skills that I don't think cost any of us much of anything in terms of, again, the whole point of communication is for it to be heard the way you sent it. And so, a few minor steps in that may improve that process. Yeah, you had your hand up a minute ago.
No.
Yeah, good.
Yeah, before.
Yeah, before.
She answered my question.
Okay, great.
See any backlash in regard to the hostile environment? As an example, I work in an industry typified by small professional firms with fewer than 20 employees. In the wake of the Clarence Thomas and Anita Hill thing, when secretary was in the news, I heard several male principals say they wouldn't hire women because of fear of sexual harassment. Probably not an issue at an institution like ASU, but have you seen backlash specifically with small businesses not going out of their way to not hire women because of fear of sexual harassment lawsuits?
I think in those early days, yes, you probably did see some of that, but I think the realities of the marketplace and economics, that went by the wayside. I think nowadays that's just not an issue. I mean, if you're a firm that has fewer than 15 employees, you're not covered by any of these laws. Now that means 15 in total, regardless of where the physical locations are. And so you don't hear too much about that kind of thing. The biggest issue that I think does still exist is the fact that harassment's defined by the impact of the behavior. And so how do you learn other people's values, their levels of tolerance, where their boundaries are with respect to certain kind of language? There have been some interesting examples of, again, this happens to be male and female, where a woman uses profanity, vulgarity, tells jokes, etc., and does that with 2 or 3 men, and yet a third guy comes along and responds to her in the same vein, and then she accuses him of harassment. And so, for this third male out here, it's like, wait, what's going on? I mean, I've heard you use this language with other males. Why are you now suddenly offended by my use of it? And again, it goes back to the impact situation. I know you two, we're friends, you have permission. You don't. You came into a conversation uninvited, and you used certain language in a particular way, and you made assumptions about me which are inaccurate. And in at least one case, this was back in Kansas, the court agreed. It said just because somebody uses this kind of language in one context does not mean she has to accept that from any and everybody who chooses to dish it out. Yeah.
How are these cases usually resolved? It seems that Clarence Thomas got promoted.
Again, due to some legal changes a few years ago, it's now possible to sue companies and actually end up with a significant amount of money. That significantly changed the landscape in terms of how employers view the seriousness of the issues of harassment. Prior to that, most employers got, for all practical purposes, a slap on the hand and weren't effectively promoting their policies or effectively trying to redress the issues internal to the employer. And there's still some interesting debates going on about how well those are working. Again, due to some more recent court cases about when is a employer liable, again, sort of back to the should have known kind of issue, that's also made employers take things more seriously, because it's not enough just to have a sexual harassment policy. You have to have one that's well implemented. You have to make sure that people are widely aware of it if you're going to use that as a defense when an employee chooses to go straight outside rather than utilize internal procedures. Again, what ASU does is a way, because we're balancing multiple issues, both from an educational perspective as well as an employment perspective, is that we talk about the issue of sexual harassment a lot. I mean, I go visit classes, I go to orientation sessions, give me an opportunity, and no matter what kind of presentation I'm making, these brochures go with me and get passed out to everybody. But we ask our folks, regardless of their status, if somebody comes to you and tells you that they've got a concern about how they're being treated, that they think somebody's using language or showing pictures or telling jokes or engaging in some other kind of behavior, make sure they know what is available to them. They can come talk to people in the EOAA office, they can talk to people in a student affairs office. Let us go through the options with them, because we'll talk to you without you being forced to put anything in writing or filing a complaint. Now we, to be honest, take some chances with some of our legal obligations, but we balance again the reality of the situation. If I force everybody to put everything in writing, I'm not going to get them to come forward to me and give me an opportunity to try to prevent some situations from actually turning into a true harassment kind of situation. We focus a lot on, if you've got concerns, come talk to us, let us try to address those concerns before they actually become sexual harassment. To give you an example, we have a process that my office calls fireside chats. It's the one process which allows somebody to come and talk to us, but we don't tell the individual, the respondent, for lack of better terminology, it's not technically a respondent, but we don't tell the individual who's come forward because there's no discipline involved. It's merely an educational conference, and we call that educational conference a fireside chat. So to give you an example, I had a woman come and say that in the middle of a discussion in a faculty member's office about writing a paper, he suddenly looked at her and said, "You see these two couches? You'll never find better love than right here in this office." And the student went, "Okay, did I have an out-of-body experience?" Appropriately said, "Oh my gosh, I forgot an appointment," and got out of the office, which was the smart thing to do. Came to our office and said, "This is the only weird thing this faculty member has done. We're 3/4 the way into the semester. I don't want him to know that it's me that has a concern, but I don't want to have to worry about going back to talk to him again. He's going to make some other off-the-wall statement." So in this particular instance, to protect her identity, met with the faculty member and said, "I need to let you know that I've had some students come with concerns about your interactions with them. And primarily you could categorize it as you engage in professional discussions with them, you introduce personal topics." Now this particular faculty member said, "Okay, I'll stop," which is not a typical response that I get to these kinds of conversations. So I asked him, I said, "Well, exactly what is it you're going to stop?" And he described the situation. I went, "Oh, yes, you need to stop that, but that's not what I'm talking about here." Now that was one of our more unusual circumstances. He's not at the university anymore by his choice, not ours. Again, it was in all honesty, an individual who was having some pretty serious personal problems, and we were able to refer him to the kind of help that he needed. Yeah.
But I understand that it's all right to have sexual harassment if you don't have more than 15 employees.
The question is, it's okay to have sexual harassment if you don't have 15, more than 15 employees. The law does not prohibit discrimination for employers that have 15 or fewer employees. So basically, that's just the way most of the state and federal law is. Arizona mirrors the Civil Rights Act of '64 in terms of the sex and race discrimination law. I used to live in Kansas, and Kansas, for its own state law, used to bring it down to if you were an employer that had 4 or more employees, you were covered by the state law. Arizona just, again, you have to have a minimum of 15 employees to be covered by these laws. Again, if you look at small employers, I don't know, because there's no way of knowing what's going on there since they're not covered by the law. No. They could actually try some other avenues rather than using it as a discrimination. And I'm not an attorney, but from what attorneys tell me, Arizona does have tort laws, intentional infliction of emotional harm or damage. So there may be other civil remedies available, but not quote-unquote discrimination or harassment.
Yeah, I think you sort of said something about this, but not. When you said slap on the hand, you got a problem where you get overreaction, and some people then you get fear, and then that's another balance that's hard to figure.
It is, and it is understandable that because there aren't very clear rules, if you engage in X behaviors, Y is the consequence, because again, it is based on an impact, and we're all different, our values, our tolerance levels are different, in the circumstances that we're in. It is very difficult, and I think it is somewhat understandable when people go to the other extreme and say, all right, I'm not going to talk to anyone then. Well, the reality is, in order to do your job or to be an effective teacher, you must talk to people, and you must talk to them in many circumstances on a one-on-one basis or in small groups. If you refuse to do that, then you are damaging yourself in terms of your performance, but you're also potentially damaging someone else in terms of not providing them the information they need to do their job. And so, again, we're back to the trying to help people remember what I would call common sense kinds of things, and that is, no, we don't all define civility and common courtesy in exactly the same way, but can you ask questions? Can you stick to, business-related topics? Can you, gradually find out? We encourage our folks to have staff meetings, and rather than talk about the issue of what's your boundary for jokes or things like that, rather talk about things in terms of define the professional environment that you want at work. What are the elements to that professional environment? And that includes dress, language, physical touching. We have parts of campus that are huggers, which is very dangerous in an employment context nowadays, to touch somebody without their explicit permission. But to talk about the things that make up your employment environment, that are day-to-day sort of thoughtless kinds of behaviors, and use that in terms of what would you like to see your professional environment be like, as a way of getting at some of these issues without putting somebody on the spot that says, okay, do you like jokes about, which is very uncomfortable. In our classroom situations, we ask the faculty, set the ground rules. You must, because if you tolerate behavior between these students who are engaging in sexual harassment of each other, you sent the wrong message to the rest of the class, and you then, again, are potentially vulnerable because you tolerated this kind of behavior in this environment. So it's, set the ground rules for your class in terms of what are the rules of civility, what kind of language can be used in that classroom environment. Not stifle, again, some very controversial discussions, but rather, I used to teach a class called Minority Studies 30 years ago now, and when I walked in, at the beginning of the semester, it was always, folks, these are the rules of class. You may say anything in here you want to. Everybody is entitled to his or her opinion. I ask you to say it with courtesy. don't yell and scream, and no name calling. You know, I'm sorry, you can communicate your message without referring to people by pejorative names. As long as you don't do that, then we're going to have some real tense discussions about, you know, differences in terms of views. And again, people didn't like a lot of the things they heard, but they didn't qualify as harassment because it was clearly an academic context appropriate to the course. Yeah.
Can an employer purchase a liability insurance to protect them against a sexual harassment suit?
You can, but again, it depends on, most insurance companies provide some pretty serious limits to that because of the dollar awards that can now be granted. For instance, at ASU, we are protected as employees by the state risk management. But again, we're not protected if the behavior that gets described is not within the scope of our employment. And if you engage in harassing behaviors, I guarantee you that's not within the scope of your employment kind of situation. So, yeah.
Yes, perhaps the greatest threat to the First Amendment was and still is this attempt to ban flag burning. And in 1989, when the court, luckily, the Supreme Court struck down the efforts to ban flag burning, Justice Brennan wrote that mere offensiveness to the observer or listener is never a basis for banning something under the First Amendment. You know, sort of, even as an atheist, that's kind of my Bible in terms of the First Amendment. And there was an incident at the University of Michigan in 1990, which I wrote about, and I found to be, again, a kind of left-wing censorship which was out of bounds. There was a psychology class, and the born-again Christian student, with whom I probably disagree on everything under the sun, made the comment, they were discussing homosexuality, that he felt that homosexuality was an illness that could be cured through the proper therapy. Well, I mean, that's, to me, even though I find it disagreeable, that's a constitutionally protected opinion, and yet a gay student complained and the university disciplined him, and it was us First Amendment lawyers that had to threaten the university. So we have to be very, very careful, and I think an answer to that would be to distinguish in an academic context between what is said to a person as an individual about them, but then to have a more or less blanket rule that protects all philosophical or topics of public policy, so that if you want to address what should and should not be the case in society. For instance, I mean, at USC, women students were complaining because in sociology class, a male student, and they were discussing censorship, defended pornography. Well, you should have a right to say pornography should be fully legal. And so I think that what we need to do is we need to focus in legally more on what is a directed insult, if you will, to the character and person of the victim, but not allow the supposed victim to claim that a difference of opinion on a public policy subject harasses them.
Right. And we actually don't get too many of those kinds of allegations. I don't know whether it's because people just don't choose to come forward, but again, one of our classics was probably about 10 years ago or so. We had a teaching assistant meeting a grad student who was teaching a photography class, and the pictures that were up on the walls in this particular classroom were designed to show a particular or a series of photographic techniques that were being taught in the class, but the subject matter was female genitalia. Oh yeah, we heard from women students in that at length. Quite angry about that. I wasn't the one who investigated that in my office, but had another person, but when he went over there, he could actually physically go into the classroom and not be exposed to these pictures. And so we offered to resolve the issue for the women who were complaining by transferring them to another class, but we were not going to demand that the photos be taken down because that was academic freedom. You could object to the subject matter, but there was a legitimate reason for those photos to be there. And so it's, you know, again, part of the balancing act. We're going to accommodate you women if you're offended by this, but we're not going to force it to come down. We did talk to a couple of people and ask why this particular subject matter. Could they not find other subject matter that would effectively demonstrate these photographic techniques. And I don't know what they ultimately decided to do, but this stayed up for a while. And again, we took a lot of flack in our office for that stance, but I'll still defend that. Again, back to what you were talking about. So it does get interesting at times. As you may know, we get a lot of outside speakers coming on ASU campus, and we call them, they're the mall folks. They stand on our malls and talk about a lot of different things, and I'll just be honest, we get at various times a year a group of, we just call them mall preachers. They're preaching one religious view or another, and we get a fair number of complaints about, you know, how offensive their language is, and again, spend time explaining that until they come up and say, you are a, and, you know, start using and focusing in on you as an individual, that's the point at which we start looking at they've now crossed the line in terms of our policies. Up to that point, we encourage, go out there and engage in counter speech. We're an educational institution. You want alternate points of view, that's the way to do it, again, civilly. I actually watched a student engage in that civil counter speech with one of these people several years ago. And I don't know when I've seen a larger crowd of students at ASU gathered in one spot. It was fascinating. But again, that was the way it should be occurring, not stifling one person or the other's speech. Other questions, comments? Back? Yeah, sure.
What about charter schools? They could have, say, 6 or 7 teachers and a principal, and the principal could harass the teachers, and the teachers could harass the children.
I'm not aware of any exemptions or exceptions to the 15 employees here in Arizona for educational institutions.
Federal law?
No, the federal law is strictly the 15 or more employees. Now,
And it's not fair.
well, and what I don't know, to be honest with you, is there's also a law that part of amendments to the Civil Rights Act called Title IX of the 1972 Education Amendments, which prohibits sex discrimination in educational entities. But that educational entity has to get federal financial assistance. So if the charter school, in some way, shape, or form, is not getting federal financial assistance, then they could probably legally engage in sex discrimination, and it might, one of the forms might be harassment. Because at least with Title IX, I don't think you've got the 15 employees. The criteria is, do you receive federal financial assistance?
Why do you suppose the number of 15 was arbitrarily chosen? Why should it have been 12?
You know, this was back in 1964. I have no idea. I have no idea. You know, when it was first passed, again, before sexual harassment became an issue, just the basic discrimination prohibition, you had to be engaged in some sort of interstate commerce. And so that they're looking at, again, to be in violation of a federal law, you have to be a certain size to warrant this kind of an issue.
Yeah, that goes back to small groups and being employed. There's a lot of law that it doesn't affect them. They don't have to provide hospitalization, or, you know. But I wanted to make a comment about Clarence Thomas back.
Okay.
If she had had the foresight to keep that pubic hair he put on her coat, and it had a follicle, she could have really nailed it.
And quite frankly, if there were different questioners, and if they had to comply with the rules of evidence that you would find in a court, you might have had a quite different outcome. I have to be honest, I finally got to the point where I couldn't watch it because I spent more time yelling at the television, which was, you know, not productive at all. But it was such a travesty that I couldn't stand it.
Has there been any serious challenges to the number 15? Has anyone tried to reduce that number?
Not that I'm aware of. I confess I haven't really monitored that, so, yeah.
15 employees, there's a whole litany of laws that doesn't apply.
That's what,
Small business administration would fight that to the death.
Yeah.
A lot of businesses won't hire that before it's 50 or 60 where those laws would affect. A lot of businesses won't hire that employee just so they don't have to comply, because the cost to comply with a lot of small business out of business.
And I think that is probably
You could forget it.
OSHA regulation, things like that too.
coming up with some real jewels on those.
This might be outside of the sexual
abuse is already, but libel and slander, I understand that one of them is written, the other one is verbal. Is that right? I think it might be interesting to some people to go on Google and put in my name, P-A-U-L, P-U-P-D, 2 words. And the stuff that is on there about me, you know, is kind of interesting, and not necessarily sexual at all.
And it's on the web or?
Yeah.
It sure is, it's all over.
Uh,
We can-
You know, yeah,
well,
please.
the way to answer that is that unless something is a provably false statement, it's not defamatory. For instance, there are about 10 references to me on the web having debated a Christian presuppositionalist, and about 10 Christian websites triumphantly say that Professor Bonson showed Tabash that he can't even brush his teeth without the Christian worldview. Now, I would never want to live in a society where I could sue over that, because that's pure opinion. The same thing as when I read my office from Alan Isaacman, Larry Flint's attorney, when Flint won that major Supreme Court case against Falwell. What happened was, in the 1983 edition of Hustler, Flint showed Falwell in a cartoon having his first sexual experience with his own mother in an outhouse. And Falwell sued, and the Supreme Court ruled, no, that's parody against a public figure, and no one could think that this is truthful. So unless someone accuses you of something which is a provably false assertion, it's mere opinion, which is and should be constitutionally protected.
I work in a legal office, and we just had a suit similar where, I won't go into the details, but a doctor was accused of being a Taliban doctor in medical malpractice and all this. And the judge blatantly said, "Can you prove all this?" And he said, "No." He said, "There's not much I can do."
You know, but back on the topic of harassment, because our time's running out, who engages in harassment? It's not a respecter of, you know, race, sex, age, religion, national origin, disability. You have surprising kinds of people who engage in it. Sometimes it is quite unintentional, you know, again, not paying attention to what the impact of the behavior is and letting it go so far that it does technically qualify as harassment. There is a greater tendency for some people probably to engage in harassment, and those are people who abuse power or who are trying to demonstrate their power in inappropriate ways. Interestingly, at the university, the largest type of complaint we get are female grad students against male faculty. And there are a lot of things that go into that. Part of it is it's a lot of one-on-one contact in graduate education. There's a lot of combining the social with the professional, again, quite legitimately in an educational context. And so you've got proximity and opportunity, and there's a real serious power imbalance in terms of the role that a faculty member plays in making sure that a student can graduate successfully with that graduate degree. And there are people who may not start out, you know, intentionally trying to make somebody's life miserable, but again, don't remember where those lines are and when to say, you know, this is the professional. One of our worst cases was of a faculty member who found out or identified a student because he sat on a PhD admissions committee. She was not admitted into the department. She was an international student. So he started, by the way, his faculty is not there anymore for obvious reasons, as you'll find out. But he started corresponding with her, letting her know that he could get her a job working for him, and that once she started working for him, he was pretty sure he could get her admitted into the PhD program. So you see a 3-month email correspondence that starts off very, you know, sort of professionally, although promises that were inappropriate, and then starts to become much more personal in terms of what do you like to do for fun, how close a relationship do you like to have with your mentors, and ending up, not the worst, but one of the more awful statements was advising her to make sure to get birth control before she came to the U.S. Because it would be a lot easier for her. Now, when I talked to the individual, number one, he lied to me. I asked him if he had an email exchange with this student and said, well, yeah, but it was just a little bit. And so I printed out the stack of, these weren't all of them, and said, would you define this as a little bit? Because it didn't matter which printer you were using, it was just, and I had his emails as well as hers, because she diligently kept all of these, and started asking him some questions about, did he ever use the phrase close personal relationships, and said, no, never used that phrase. So then I showed him the email and said, is this email actually from you? Because again, you never know whether it's the right sources. And he finally acknowledged that. But in his mind, he did not violate anything. He was not engaging in quid pro quo harassment, because one paragraph was about the job and third paragraphs were about the personal situation. And that in his mind made a distinction that we apprised him ASU did not agree with that distinction, and so he is again not employed there anymore. ASU's policy is, if we have the evidence to substantiate quid pro quo harassment, that is, we will terminate you, whatever it takes. We will terminate you through our policies, legally, those kinds of things, but we're not going to tolerate that kind of behavior. And, again, an institution our size, there are very few people that we've actually made that recommendation for, but occasionally that does happen. So again, harassment is an abuse of power, plain and simple. The tool that gets used is sexuality in most cases, or in a lot of cases, and it's an area where a lot of people are vulnerable. They don't know what to say, how to say it, or how to respond, because usually the person who's engaging this behavior is somebody that you at least initially trust. It's your supervisor, it's a coworker, it's a faculty member, and you don't expect this kind of behavior to be directed towards you. Or if it's, again, somebody tells a joke and you respond by saying, I really don't like those kinds of jokes, there's an expectation that the behavior will stop around you. And when that doesn't happen, there's a process that some harassers go through that's called grooming, and it's a desensitization process. To allow them, in the case, for instance, like physical touch, in our, again, work or educational environment, we have a lot of students who work in a faculty member's office, and so it's initially they're looking at a computer and the faculty member gets very physically close, and the student might flinch or something like that, but over a period of time, you get used to this person being that physically close to you, maybe touching, putting a hand on a shoulder, or something else. You have a lot of personal conversations that start occurring, and then finally somebody does something that really does cross the line. But a lot of times people won't come forward because they feel culpable. Now that as I reflect back on what happened, I can see the progression of behavior. Why didn't I stop it back then? And we try to remind people, don't beat yourself up, because you can't foresee everything that's likely to happen. Not everybody, again, this desensitization process is not automatically designed for harassment. Sometimes it is a simple difference of values in terms of how physically close people are comfortable with each other. And it's just, when something else. Because for a lot of people who feel like they've been harassed, there's a lot of guilt associated with that, which again keeps people from reporting it, because somehow they feel like there's something that they did that warranted this behavior or that caused this behavior. And as we tell folks, unless you consider harassing behavior to be an appropriate response to anything, there is nothing that you can do to incite or provoke harassment. Two wrongs don't make a right kind of situation. Having said that, however, one of the things we tell our students, again, we're in Arizona, it gets very hot, you look at the fashionable styles, and given what some of our males and females, and I will be honest, particularly our females wear or don't wear nowadays, while that attire, we say, hopefully that will not be viewed as harassment, but I hear from male faculty that says, again, they are truly offended by, it's very difficult not to focus your eyes in certain places given what is or is not being worn.
In that reverse sexual harassment?
Yeah.
Sexual harassment, again, males can be harassed by females, males can harass males, etc. And so, back to the example we give, and that is, I'm grateful I'm not teaching anymore, because I guarantee you, if I were in this environment, I would start by saying, folks, there's a dress code in this class. I don't care, bring a towel, whatever, but you better be covered from here to about here, male and female. And I'm not sure whether I could get away with that. I have to think very carefully about that. But again, it is very distracting in many cases. And so you know, a lot of our faculty are very concerned about, I'm the one who's going to be accused of harassment, and here's somebody wearing an exceptionally low-cut and high-cut outfit, and where are my eyes supposed to go in that kind of situation?
Does the university ever consider a dress code?
It would be practically impossible for us. We have certain departments within the university that have dress codes, but if you look at the range of activities that occur, that would be really tough to, you know, unless we demand that everybody wear a uniform. And again, as a public entity in this day and age, I wouldn't want to fight that battle. I have to be honest.
Classrooms are a little different than around the campus.
I agree, but again, it's based on whose value gets to prevail. You know, the faculty member, in some ways, his or her value has greater weight in some circumstances in that classroom, but not totally. And so, again,
Isn't distracting the class, though, something a professor needs to consider?
but again, you know, you have to find a practical way. I mean, the other thing, quite frankly, faculty think of, if I make too great an issue of this, nobody will take my classes anymore. And so you start looking at, again, a range of issues.
I was just going to say I have a very close friend who just retired from ASU after 40 years. And one of the dress codes he had in his class was nobody wore hats.
Oh, okay.
He just didn't like what they looked like and they put
Yeah.
them on backwards, and he just said no hat.
We do have people, I mean, now then, you know, so many folks have cell phones, and again, I am constantly amazed. You go outside during the change of classes, literally,
Everybody.
almost everyone has that cell phone plugged in, and, you know, I keep
Not to
thinking,
their-
who do you have to talk to? Who do you have to talk about? I mean, so we do have a lot of classes that are really strict about that cell phone better be turned off.
Yeah.
If it's not, they will confiscate it during the class and return it, you know, at the end of the class.
Female graduate student aggressively pursues a faculty member, and he does not rebut that, and then later breaks off the relationship. Can she file a harassment against him?
She can file, I mean, you can't prevent anybody from filing a complaint, but whether the complaint will have merit or not is another issue. You know, just because ASU does not prohibit relationships between supervisors and person being supervised. And again, if you're a student in a faculty member's class, that's a supervisory relationship in our book. We discourage them because, again, power abuse, and it's too easy for that to, it's also a built-in conflict of interest that we have to address. But we have had examples, which I don't particularly like, but one of the classics was of a grad student and a faculty member started off with a consensual relationship by both people's definition. And then, depending on who you wanted to believe, either he broke it off or she broke it off, and depending on who you wanted to believe, she continued to pursue him or he continued to pursue her. Literally no witnesses other than these two people in this kind of circumstance. So trying to figure out, you know, who has greater credibility. I mean, I caught both of them lying to me. That I could substantiate. So at that point, I didn't trust or believe what either one of them were telling me, other than the fact that I knew there was this relationship. And that it had gone sour, and now then we needed to fix things. So we fixed the practical issues for the student so that she could go ahead and graduate. We restricted the faculty member from engaging in certain kinds of activities for a while because there were some things that I could verify that were inappropriate, but not necessarily because of that relationship. I have to tell you, had a call last summer from a faculty member who was, I've never, and I know this person pretty well, never seen him this shook up. And he said, you have to listen to this voicemail message left on my machine. It was one of the more graphic voicemail messages I've heard, and it was from a female student indicating to him what she would do in order to get a good grade for that summer school class. And she provided a range of behaviors she would engage in order to get a good grade for that class. And he said, you know, what do I do? How do I respond? I don't want to talk to this student again. I don't want to see her or anything else. And so we, you know, made sure we got a transcription of that tape. And he wrote an email to the student that said, based on the voicemail that you left me on such and such a day and time, please be advised that all further communication about this class needs to go to the department chair. Well, again, turns out that the person who left the voicemail claiming to be, you know, Susie Q, Susie Q writes back and says, "What are you talking about? I didn't leave you such a voicemail. How dare you?" And so now we're back in the business of trying to identify, okay, who sent the voicemail, you know, and you just start working through the various steps on that. But again, sometimes you do have to remind faculty, actually you have some legitimate authority, and that is if you're being harassed by a student, it's a little bit easier for you in many cases to put a stop to it. You can administratively withdraw the student. Now, if the student engages in behavior, you know, towards you at your own home, again, sadly, we recommend people call the police at various times because we're now into the stalking. We've had some faculty actually be stalked by students, some same-sex, some opposite sex, although the issue was clearly sexual harassment.
So if it's not education or employment, but let's say it's a neighbor that's harassing you. I mean, making, you know, verbal comments. Is there no protection?
You have to go through some other civil law, but not discrimination law to try to
Apart
address
from
it.
order of protection, which means that you can't see them. But I mean, if it's a neighbor or somebody that you know that's...
Right, it would not qualify as discrimination under these kinds of laws. What we're talking about today has to be in the context of employment or an educational environment. Again, we take issues that arise outside the university environment, but because these two people have to come back and work together, or because one is a faculty and one's a student, we're still going to address those issues. You can't just say because it occurred up in Scottsdale at 8 p.m. on a Saturday that it has no relationship, because but for their ASU connection, they wouldn't have been up there. And so we look at those kinds of issues, again, to try to fix things. But again, if it's purely neighbors, then no, this kind of issue doesn't arise. Let me also make sure I mention a couple of other things as time winds down here, and that is, if you feel like you are being harassed, if at all possible, some very basic steps. One, say stop. Say no. You may not feel comfortable doing it at the time, depending on the environment that you're in. Practice with somebody else. 2 months later, go back and say, remember, you may or you may not remember, but 2 months ago, when I walked into your office, you said, "Hey, girlie, I just wanted to let you know that I was offended by that term, and I'd really appreciate it if you don't use it again." And then you walk out. You know, you don't have to make a huge issue out of it, but again, you do let somebody know, because in many cases, most of us would change the behavior if we knew, in fact, it was offensive.
So then isn't that just a personal failing on everybody's part, that they're not strong enough to stand up to it?
Well, I don't know that I would call it a failing, because again, most of us don't get taught how to do this and feel comfortable about it. And particularly, I think there are some stereotypes or socialization stereotypes between males and females that make it difficult. Because the problem is, for a lot of, and again, I know this happens to men as well, but you're in a situation that you're uncomfortable and you say to somebody, "Stop," and the immediate response is, "Oh, where's your sense of humor? Can't you take a joke? What's wrong with you? Don't be a prude." So you get a worse reaction than if you said nothing. And so it's getting past that kind of perception that you'll be treated worse if you say no. And that takes a lot of encouragement for a lot of folks, again, depending on who it is that they're interacting with. But if at all possible, let somebody know, again, very politely. We also tell people never, ever, ever accuse somebody of sexual harassment. There are folks out there that recommend you write letters. You know, by all means, if you're more comfortable, describe the behavior and how you felt about it, but do not use the words, "Stop sexually harassing me." Now we're back into the you've made a false statement, because who determined? Potentially, we don't want to give people inadvertently grounds to come back after you for making false allegations or things of that sort. And it's far more effective to say, on such and such a day, you said this to me, this is my reaction, please stop, and limit it. We also encourage people to take notes, write it down. You know, it may be your recollection, it may not be totally accurate, but you need to start working through some of the anger. Because in many cases that anger turns to feelings of helplessness, and then you really do start to believe that somehow you caused this treatment towards yourself, and we like to, you know, try to avoid that kind of situation. And just keeping a journal of who, what, when, where, even if you never complain, sometimes helps work through some of that. Good.
Going back to the dress code for women, it is interesting how women are less valuable than money. If an accountant or a banker has money in front of them, they know it doesn't belong to them and respect it. But a woman, it doesn't matter the amount of clothes that she wears or the behavior that she has, she is entitled to be harassed. For instance, with the Mexican women, the murder that has happened in Juarez, one of the excuses that society says is they were out maybe too late, or they were wearing inappropriate clothes. So the right to be alive for a woman depends on how late she was out or how many clothes she wore. Now, a professor that gives excuse that he cannot focus because the woman is not wearing enough clothes, I think that that is very disrespectful and he shouldn't have the merit to do that.
You know, I understand what you're saying, and I think you've got an excellent point. And again, we talk to folks about the fact that, again, somebody's attire, however inappropriate you think it may be, is not a license to also behave inappropriately or automatically devalue them. By the same token, I think, again, back to this balancing act, and that is, there are some things that people can do tragically to make themselves more vulnerable. Now, it may be unintentional, but again, when you know the realities, it may not be fair for women that you can't walk safely alone in the middle of the night. And you know, I'm one of the people who say that's an unfair reality. But if that is a reality and you're aware of it, then perhaps you ought to try to find a way to change that other than going out and testing that on your own. So I really do think there are some balances there. You know, I understand the need to be stylish, but again, let's look at the environment that we're in. Is this really the best attire for that environment? But either way, no one else has a right to treat them inappropriately because of that attire.
So if we translate that to a primitive society, women wouldn't have any right because they are nude in a tribe, in an indigenous tribe. So it's like if we don't establish categorically what is appropriate here. Appropriate is that no matter what type of clothes I am wearing, you are not entitled to come to me. Like money, you are not entitled to that money if it doesn't belong to you, period.
Right, that's a good point.
Well, then the question then, of course, is when does clothing, when does behavior rise to the level of being an invitation?
Yeah.
I don't know.
Again, when it reaches that court standard of it's pervasive enough and or severe enough to literally alter your environment, that you know, again, something appreciably changes. Not just a perception of a change, but there is, you know, a true kind of change in that environment. And again, employers make those definitions within the context of their employment, and if people don't agree, it ultimately ends up in court. Somebody over here had a question.
I was just realizing I could, at times, be letting myself into these things. It's kind of, one of my philosophies is I like to provoke people. I like to give people enough rope to hang themselves, and I like to get people to open up and figure out what they're talking about.
Right.
And in that way, I mean, I'm letting myself open.
Depends on what your topic is. You got to remember, again, and the context of those conversations. Is it employment? Is it an educational environment? Again, where people are, to a limited extent, somewhat of a captive audience. If it's purely social, has no other connection, you know, if people don't like it, they can be rudely blunt or get up and leave, something of that sort. Again, I think employers are starting to take the issue a lot more seriously than in the past. Again, tragically, for not necessarily the best reasons, but again, for whatever reason, hopefully there's a lot more emphasis on it. I think we do have to worry about people going to one extreme or the other, rather than recognizing that in many cases, in making a determination of harassment, there is a balancing of rights that has to go on here. In terms of, you know, does this really qualify as hostile environment harassment because it's pervasive enough, it's severe enough. By the same token, again, I think there are a lot of employers who are doing some good things out there, and certainly educational institutions are taking it more seriously. I think public schools may need to take it even more seriously because there is at least a perception in some areas that there's still too great a tolerance of behaviors between two students. And, you know, we're starting to see more court cases about the school's liability or lack thereof in terms of, again, knowledge, what they know, what they do, some of those kinds of things. But to me, what is most important is that, again, I be aware of the impact of my behavior, that I be thoughtful about the language that I use in certain circumstances, that I be thoughtful about where my eyes focus, how I refer to people, some things that I do have control over, that don't cost me anything, to try to, again, think about the impact and worry about, you know, am I engaging in behavior that's going to be offensive to someone else, when my object is always to communicate effectively. And sometimes I need some reminders about that. I think we all do. And hopefully that's when somebody says to me, stop, Barb, you know, I really don't like that language, and I can evaluate, you know, what to do about that. Whether to have more discussions, stop the language, or what the circumstances are. Last questions. Yeah.
If a man is a flasher, isn't it his own fault if it's hacked off?
I don't know. I don't know that a court would see it that way, actually. But, I don't know. Anybody else want to answer that? Interesting question.
What was the question?
The question is how many cases. ASU has 57,000 students. We have about 8,000 full-time regular employees and about another 4,000 to 5,000 part-time temporary employees. Actual cases of harassment, we get maybe 10 a year. These fireside chats that I mentioned, we probably do just in our office, the three of us, maybe 50, 60. So it's a really low number. The tragedy is you don't know what that's telling you, because harassment situations are viewed much like sexual assault. You figure about 10% of everything that's going on out there may actually get reported. Again, the good news is we get those fireside chats, so we can alert somebody to how their behavior is being perceived before it really would qualify as harassment, if in fact.
We didn't hear the funny question. That's the one we
Oh, I'm sorry. The funny question, will you stand up and repeat that?
If a man is a flasher, isn't it his own fault if it's hacked off?
If a man's a flasher, isn't it his own fault?
Thank you very much for letting me share part of your time.
Legal question. Good legal question.
If you appreciate the Humanist Society of Greater Phoenix and would like to see more, then subscribe to our channel and check us out on Patreon. Links are in the description.